By the second half of the 20th century, I think that things got a lot more complicated, and you had a continuation of this process of trying to use the law to address material inequality through things like the Family Law Act, through things like the Trade Practices Act, for example, that recognise that it's all well and good to pretend that a corporation's a natural person and so is an individual, but in reality we know that's not the case, and so let's redress some of that imbalance in market power through the law. So you had a deepening of the law for those progressive ends, but what you had also on the other hand was an increasing, I think, pulling back as governments and big corporations said, well, this is all well and good, but it's actually quite expensive for us, and we'd rather not pay the taxes to do all of this. How do we pull back without causing a riot? And so I think that during, especially beginning from the 1970s onwards, one of the techniques was to try and unwind some of those things that progressives had gained, and to begin to replace substantive rights with procedural rights. So, for example, during that period, you start to lose that United Nations Declaration idea of a right to housing, and instead you have a right not to be unfairly evicted and instead take it to a tribunal. You start to lose that United Nations middle of the century idea of a right to a job, and instead you have a right not to be unfairly dismissed and instead take that to a tribunal. And you can see this happening all over the place. You lose the right to have a pension, a legally guaranteed pension that's part and parcel with your right to be a citizen, and instead you have a right to manage your own superannuation fund. And instead of being an equal legal subject that has their rights, their substantive legal rights protected, what you instead move to is a space where the legal subject is basically made to be responsible for their own decisions, and opportunity replaces entitlement. So that's one thing that I think has happened. The second is that we've seen this prevalence of the idea of emergency or necessity being used as an excuse to suspend basic legal rights. Now, that's always been there. It's always been understood that governments, in times of war, for example, have been able to say, well, the usual legal practices and principles that are applicable under the Constitution are now going to be suspended. What I think we're seeing, though, is that the exception, certainly in the last 10, 15, 20 years, the exception is becoming the rule. And we're seeing governments more and more realising that by declaring something emergency, by declaring something to be exceptional, they can get away with enormous things, and indeed sometimes get away literally with murder. In the sphere of criminal law, that became particularly acute in the years after the attacks on the World Trade Center. In the US, you could look at the Patriot Act and see very much that was based around removal of rights, but here, closer to home, you've of course got the terrorism legislation that allows governments to declare certain organisations effectively devoid of legal rights, and to remove a lot of the rights that individuals used to have, particularly around right to silence. And I think it's no coincidence that the same week that those terror laws were passed, there was also the legislation that set up work choices was passed as well. And you had the beginning of this idea that certainly, say, in the building industry, that because the building industry is so outrageous, workers in the building industry no longer deserve the right to silence. And so we can pull them in front of the Building and Construction Commission and make them answer questions about who was at meetings, and if they don't answer, they face 6 months imprisonment. And that's justifiable treatment for this particular group because their situation is so dire. You see it in migration law, particularly with the exclusion of parts of Australia as not being really Australia for the purposes of the Migration Act. Of course, Australian government still has complete power there, but if you happen to land there, you have less rights than someone who might have landed somewhere else. And I think in that context, it's absolutely no coincidence that what we saw with the Northern Territory intervention was called the Northern Territory Emergency Response. The idea was that by saying it's an emergency, we can remove the rights that would otherwise apply. We can suspend the operation of the Racial Discrimination Act, and we can pay absolutely no attention to the principles that underline both the general United Nations Declaration but also the United Nations Declarations on the Rights of Indigenous People that say a priority, if you are going to invoke special measures, is that you get people's consent before you do things. Or whether or not you're going to invoke special measures, consent ought to be a priority. By calling an emergency, it allowed governments to completely override all of that. And I think that that's the second. So when you look, first of all, at this move away from substantive rights to procedural rights, and secondly, at this idea of the prevalence of calling something an emergency or calling something exceptional, what does this all mean? Well, I think it means that at the end of the 20th century and the start of the 21st century, where we find ourselves, that our abstract legal subject that progressive law used to critique has actually been through the ringer a fair bit over 100 years and has come out now at quite a different place. We have, and I'm caricaturing a bit here, but we now face a situation where legal subjects, the abstract legal subject as a whole, is beginning to be emptied of meaningful rights that will stick through thick and thin. And the idea of equality is increasingly being thrown by the wayside. And real equality is certainly disappearing in favour of procedural, but even the procedural side of it, it's no longer as universal as it used to be. And I think that's why, for us as progressives, despite the criticisms that have been made by many about the limitations of thinking about abstract legal equality, I think at this time, here and now, for us, one of the big tasks for us is to give equality back some real meaning. And I think that that means giving it back both substantively and materially, and saying, well, let's have a discussion again about what it would mean for everyone to really have adequate housing, not just the right not to be kicked out when their rent goes above 4% or whatever it is, but for actually to have a real right to have housing, what it would mean to have material equality for Indigenous Australians, and not just equality that's there at some point in time and can be suspended, and not just equality of opportunity but actual material equality. And what would it mean for legal rights to stick through thick and thin and to not be able to be removed by governments because of prevailing political debate. And I think that that's crucially important, and they're things that 30, 40, 50 years ago might have been taken for granted, or 100 years ago would have been the very things that have been fought for. But I guess what I want to suggest, and to finish on this note, what I want to suggest is that those, what might be old ideas of equality, and what might be ideas that have always had their limitations, are probably now more important than ever to defend. Because I certainly don't want to be in a society where rights are contingent on government deciding from day to day whether I'm going to have them. I don't want our rights to be contingent on governments deciding whether or not, in some unappellable way, whether or not we are in an emergency. And I don't want the right to have my welfare looked after, that's referred to in the United Nations Declaration, be reduced to a right to have to manage my own superannuation fund if, for example, I find myself in the situation of, or if you find yourself in the situation of a 45, 50-year-old woman who's been out of the workforce for a period of time, who now finds herself divorced. I mean, what kind of superannuation entitlements are you going to have to fall back on then? And it's only if we put that idea of real substantive equality back centre stage that we're going to be able to effectively campaign for some of those things in the way that progressive lawyers would have 100 years ago. Last thing is, I want to say that I think that during this term of Parliament, there's a real opportunity that we'll actually be able to put some of this in practice. One of the agreements that was reached between us or one of the elements that was reached in the agreement between us and Labor was that we would have, in this term of government, a referendum on recognising Indigenous Australians in the Constitution. And that there is now a process that is set up where there is a reference committee that is looking at what that might mean. I hope that they will come up with something during the course of this term of Parliament. That's certainly their intention. That could mean that we are in a situation where we have a real chance to redress some of these things that I'm talking about and to put the importance of full equality back on the agenda. So I'd hope that you all just keep your eyes open for that over the coming years, and if we do end up in a situation where we're having a campaign to change the Constitution, it would be a pretty exciting campaign, I think, to be involved in. So thank you very much for inviting me to come and speak to your conference. I think it's a fantastic, as I said, testament to all that so many of you are here on a Saturday morning, and I look forward to providing you with whatever support we can from our office over the coming years, and wish you every success. Thanks very much.